Hey everyone, welcome back to another week of KNR 382. We're moving on to the second part of our negligence unit today, and there's actually quite a bit of content here, so I'm going to try to split it in between two videos so that it's not one big chunk, and you can take it in pieces if you want. So the first part of our lecture today is going to cover what your textbook goes into for this week, which is the potential defenses available to, say, a defendant in a negligence lawsuit. So we'll switch perspectives from what we did last week, which was look at negligence from the perspective of the plaintiff. Right? We looked at the different elements that had to be proven by the plaintiff in order to be successful in a negligence claim. And this week we're going to switch that perspective to the other side and start to think about the different defenses that might be available to, let's say, a KNR facility if they are sued in a negligence claim. So that'll be the first part of our lecture today. The second part will go into some actual application of negligence. So we'll look at the different types of negligence lawsuits that commonly occur in our field. I'll give you some examples of those. So your textbook doesn't really get into that, but it is really important that we cover that content. I will say that your quiz this week will cover both the reading and the lecture series, so you'll want to make sure that you listen to part 2 of this as well, because there will be some questions specifically pulled from the second part of this lecture, so keep that in mind. It's also just really important content for us moving forward as we start to look at some case studies next week, and also when we get to exam time, so definitely make sure you're watching both parts. Okay, so again, I want to start by talking a little bit about the potential defenses available for someone if they are sued in a negligence claim. And your book goes into quite a bit of detail on a number of these defenses that are available. We're just going to focus on some of these ones that I think are most important. We're not going to spend time looking at all of them, although I encourage you to read about all of them in the reading. Important to keep in mind that as we look at these various defenses, that every state is different in how they actually apply these legally. So I'll try to make note of it when possible about how Illinois might utilize one of these, but keep in mind that some of you might move to different states after you graduate, and those states might have a different way of applying these defenses. So keep that in mind, that every state is different in how they interpret and apply some of these concepts. Okay, our first potential defense here is pretty straightforward and probably the easiest and best defense for someone in a negligence case, and that's failure of proof. Basically, you can show failure of proof if you can prove that even one of those elements of negligence doesn't exist. So as the defendant, if you can attack one of those elements and show, hey, there was no duty owed here, or hey, there's no actual causation, you can't actually link breach of duty here to the damages or injuries that occurred, then you could show failure of proof. Basically, you're arguing the other side doesn't have a case, right? Because they can't prove all 4 elements of negligence. So again, pretty straightforward here in terms of what this looks like. Really, before you look at any other defense, you should probably start here. Can we possibly argue that one of these elements doesn't exist? And if so, we should probably start there because it's going to be our best line of defense. Okay, so these next 2 concepts rely on this premise that, oftentimes these situations aren't black and white, meaning that oftentimes the plaintiff might actually play a role in causing their own injuries, meaning that it's not just the defendant facility or owner that was negligent, that sometimes it's a little bit more gray than that. It's not necessarily black and white. So this first one, comparative negligence, basically says that if the plaintiff was deemed to have any conduct that was negligent on their own behalf, then the amount of their damages, so that monetary reward, is going to be reduced based on whatever fault the court deems appropriate. So for example here, I've given you the case of Will Jenkins, which was the case study we looked at last week in that big state university case study. So if you remember back to that, Will Jenkins was the plaintiff. He was the one that fell on the water spill that was left at the fitness center, and he successfully was able to sue the fitness center and the fitness center employees. So let's go back to that case and change the details up a little bit. So let's say that instead of simply walking through the facility and tripping on the wet spot, let's say actually Will was running, right? Maybe he's running late for the day. So he decides, hey, I got to run and get this workout in if I'm going to get to work on time. So in that case, things look a little different, right? Now, Will might be deemed partially responsible for his own fall, right? If he hadn't been running, maybe he doesn't fall on that water. Maybe he sees it, he's able to sidestep it. So if Will lives in a pure comparative negligence state, you can see I've shown you here what might happen to his reward. So we said earlier in the case that Will had been awarded $1,500 in damages. That was for the physical injuries and the lost time at work. But let's say in a pure comparative negligence state, the court says, hey, this is 50% your fault. If you hadn't been running, this might have been less likely to happen. So the court has assigned a percentage, right? 50% of this negligence falls on Will. The other 50% still falls on the fitness center, right? So in a pure comparative negligence state, Will's initial damages are reduced by 50%. So you can see what that looks like here, right? Instead of getting $1,500, he's going to be rewarded $750. So he's still getting some financial reward, but it's reduced based on the level of negligence that the court deems he caused. So basically, his percentage of fault is what reduces that initial award. So that's what happens in a pure comparative negligence state. Like I said on the past slide, every state is different in how they apply these laws. In some states, they have a much more severe version of comparative negligence, and what we call contributory negligence. So basically, there are a handful of states here in the U.S. that say, hey, if you, the plaintiff, contributed any percentage to the cause of the accident, then you get zero. You get nothing. Now, obviously, this is much more severe than the comparative negligence because in those cases, you're simply reducing the amount by whatever percentage of fault. In a contributory negligence state, the courts don't care what the percentage is. Basically, if they deem you to be 1% at fault for your own injuries, then that's going to lead to a complete bar to any kind of reward. So you can see I also gave you the Will Jenkins case here as an example. So if Will lived in a contributory negligence state instead of a comparative negligence state, you can see is a pretty stark difference in what he walks away with monetarily. If it's a contributory negligence state, he's getting nothing. Now, like I said, that's much more severe, and because of that, only 5 or 6 states actually apply this concept, because as you can imagine, it would be pretty hard to win a negligence claim because, really any defendant can argue some fault on the part of the plaintiff. So in these types of states, it's much more difficult to win a negligence claim if you are a plaintiff. Keep in mind that in Illinois, comparative negligence is the standard. So that's something to keep in mind as you think about how this area of defense might apply to us as practitioners. Okay. So another line of defense available to K&R practitioners is this concept of assumption of risk. Basically, what you're arguing is that the plaintiff knowingly exposed themselves to some kind of risk, right? Basically, they knew what they were getting into. They knew there were these inherent risks associated with the activity they were going to do, and therefore the plaintiff shouldn't be able to recover any damages for injuries that occur. So how might you prove this? Well, there are basically 3 different categories of assumption of risk. We have what's known as express assumption of risk, which basically says, the participant told us either verbally or through their writing that they agreed to accept responsibility for the inherent risks that they're about to face. So this one's pretty easy to prove, right? You can either show that maybe they signed a waiver that shows they expressed assumption of risk, or maybe they verbally stated it to an employee before participating in the activity. So express assumption of risk, fairly straightforward in terms of proving. These other two are a little bit harder to prove if you're the defendant. So secondary assumption of risk is basically when a plaintiff voluntarily chooses to encounter some kind of risk, and there is some level of negligence on behalf of the service provider, but basically the plaintiff knew that and went ahead and took on the risk anyway. So for example, let's say a group of young adults wants to play baseball on a field. They note that the field is in poor condition, that there are lots of holes in the ground, rocks that shouldn't be there. They see that, and despite knowing that those risks are there, they go ahead and play the game anyway. That would be an example of secondary assumption of risk. Basically, there were some clear and obvious risks. Even though there was some negligence, those people chose to take on that risk. This last type of assumption of risk is called implied assumption of risk. Probably the most difficult to prove if you are a defendant. Basically, you're saying, there's an implied level of risk to this activity, right? We know that when you participate in a sport like whitewater rafting, that there are certain well-known implied risks to that. Drowning would be one, right? So if you are a practitioner who owns a whitewater rafting company, you could certainly argue that in court that these are well-known risks, but you would be much better off if you could show that there was either some express assumption of risk, so show that that plaintiff had signed a waiver or had verbally agreed to acknowledging those risks. So certainly secondary and implied assumption of risk can be useful, but probably your best case scenario is to get something in writing, right? List the potential risks, make sure that your users and members are acknowledging those risks so that you have that document to fall back on. And we'll circle back to that concept of waivers here in a little bit. Okay, our next potential defense for a recreation practitioner would be this concept of immunity. And immunity is kind of a generic term that means, exemption from penalty or liability. In the context that we're looking at it, basically we're talking about exemption from penalty in a negligence case. So keep in mind that when we say immunity applies to certain recreation organizations, we're saying that only in the case of negligence. So this doesn't provide protection to those companies in cases where an intentional act has occurred or a reckless act has occurred. So we've got basically 4 different types of immunity that exist in our field. And your book goes into some detail on these, so I'm not going to spend a whole lot of time, but I do want to highlight a few things here. So governmental immunity, as you can imagine, refers to the government, right? Primarily speaking, the federal government. So basically there are laws in place to provide some level of protection or immunity for the government from being sued. If you think about it, whether it's the federal government or an individual state government, those things are funded by taxpayers, right? So if we think about just opening up the doors and allowing anyone to sue the government, basically we're suing the taxpayers, right? It's the taxpayer money that's going to be paid out there. So there's always been some level of immunity for those government officials. Basically, it allows public officials to do their jobs without threat of some kind of lawsuit. So in our field, that means, park districts, national parks, in some cases public schools. There can be an element of governmental immunity or protection to those individuals. One important case that is relevant here is Barnett versus Zion Park District. This is actually an Illinois specific case where the Park District was able to argue governmental immunity to protect them in this case where a young boy drowned in a public Park District pool. And basically, the court said that even though this young man died due to the inability for the lifeguards on staff to respond and save this young man, that because they were providing proper supervision and that they had the appropriate number of lifeguards on staff, they were able to utilize their governmental immunity and avoid paying any penalty to the family of this young man. It's important to say that with any of these types of immunity we'll look at, that the protection level has gotten less and less over time. Essentially, different laws have been passed to provide the government less protection over time. So today, more and more you do see these lawsuits where the plaintiff is able to be successful against the government. And that's becoming more common. Basically, that level of sovereign protection that once existed no longer exists thanks to a handful of laws that have been passed, where basically we don't acknowledge the same level of protection that we once did. Recreational use immunity is another important one for our field. Basically, it says that, hey, if you own a lot of land and you're willing to open up that land to the public, say you own land and people can come and hunt or camp or fish on that land, that we want to provide some level of protection to you, right? Meaning that if someone is injured on your land when they're participating in one of these recreational activities, that you're provided some level of protection, right? You can't be sued by them. So generally speaking, folks that open up their land for recreational use are provided some level of protection against ordinary cases of negligence. Okay, so two other types of immunity I want to mention that I think are relevant to our field. This first one is charitable or voluntary immunity. So basically, if you're willing to volunteer your time to a nonprofit or a charitable organization, you are provided some level of immunity against a negligence claim. One that's particularly, I think, applicable to our field is this Volunteer Protection Act of 1997. So this is passed under the Clinton administration back in the late 90s. Which basically said, hey, if you're willing to volunteer your time as a youth umpire or coach in some kind of nonprofit sport league, then we don't want you being sued. We don't want you to have to worry about that threat. So that's an important one for us, right? We rely heavily on volunteers, whether they're non-paid or paid, to come and work for our organizations in some kind of part-time capacity. And it's important for them to know that, hey, you have a certain level of protection under the law here, meaning that you can't be sued for some kind of negligent act that occurs. Now, keep in mind that just because volunteers for your organization can't be sued for negligence, that doesn't necessarily protect you as the facility owner. So it's important that we're still providing proper training and instruction to people that work for us in a part-time capacity or volunteer their time, because these immunities don't necessarily cross over to the owner or manager. So important to keep that in mind. Last immunity here that I want to mention is this concept of Good Samaritan statute. Basically, every state has some kind of Good Samaritan statute that says, hey, if you're willing to provide help for someone in need out in the public, let's say someone is choking, you go up to them and provide CPR. We don't want a situation where people are afraid to go up to others and offer help who might need it. So we don't want people to be able to sue someone in those instances. So say you offer CPR to someone out in public, maybe you're not successful in providing that. We don't want them or their family to come after you later saying you weren't able to offer proper emergency care. So these Good Samaritan statutes are in place to protect people and, again, encourage people to do the right thing. Okay. Another potential defense that we might see in our field is this act of God defense. Basically, just acknowledges that sometimes there are unforeseeable natural disasters that occur that could result in some kind of injury to our participants, to our vendors, to anyone who might be at our facility. Obviously, these are often facilities that are outdoors, right, that are more susceptible to natural disasters. So basically, a court isn't going to hold a defendant accountable if there was some kind of unforeseeable natural disaster. This goes back to that third element of negligence, that causation element, right? Basically, if you can't link the breach of duty to the actual damages, then you can't prove negligence. So it would be difficult to prove causation in an instance where you had, a completely unforeseeable natural disaster occur. If we think back to our example case from last week with Allie, the event manager, where the participant was struck by lightning, we know in that case she was able to see the weather patterns and the radar and that the storm was coming through. But sometimes, storms come out of nowhere and they are unforeseeable. So if that were the case, she likely would have been able to use this act of God defense. But we know that it wasn't in that particular case. But certainly, these are like freak incidents that occur occasionally and important to be aware of, especially if you're working more on the outdoor recreation side of things. Okay, like I stated earlier, your book goes into a lot more detail on some of these other types of defenses that are available. Again, we just don't have time to cover it all and still get to the stuff on waivers. So I'm not going to go into detail on these other defenses. I do encourage you to check them out in the reading for this week. It is important information, but not necessarily stuff we need to go into too much detail here. I do want to make sure we have plenty of time to cover the content on waivers. So with that said, let's move on. I do want to spend some time here talking about waivers. Now, keep in mind that this is a particular contract that is utilized often in our field, and there are a lot of inconsistencies and a lot of information out there that isn't necessarily true. So it's important that we understand not just what this legal document is, but how we can build the best waiver in order to protect our organization from a negligence claim. So I think oftentimes there's either one idea about waivers or another. Either yes, they're able to be used in all cases, or no, they're never able to be used as a defense, and that's just not true. Waivers that are well written and follow the necessary legal requirements are often upheld, and they make a great defense in a negligence claim. But it is important that they are well written and they include the proper legal requirements. So that's what we're going to focus on in our content here, is really what makes a good waiver. How can we make sure that we are crafting good waivers for our facilities? I would say, I've been teaching this class, probably 6 or 7 years now. The one thing that students come back to me on is that, hey, once I got a full-time job in the field, they asked me to write a waiver. They asked me to update our waiver. So I think you'll find that regardless of the career path you take, you're probably going to be involved in waiver writing or waiver editing at some point. So it is really important that you understand the basic legal requirements. Okay, so what is a waiver? You can see our definition here. It is a legal contract. So it's a contract in which the participant or user of a service agrees to relinquish the right to pursue legal action against the service provider in the event that the negligence of the provider results in an injury to the participant. Pretty lengthy definition, but it covers a lot of important pieces here, right? One, we know it's a contract, right? So it's a legal contract between two parties. We'll talk about what makes it a legal contract here in a minute. We know that there's an agreement here to relinquish the right to pursue legal action, right? So participants, when they sign a waiver, are basically giving up their right to sue the service provider, okay? And then finally here, we know that a waiver is a protection in cases of negligence, okay? This is important to keep in mind as we're working through the legal considerations for a waiver, that really they only protect a service provider in cases of ordinary negligence, right? So not in intentional acts, not with reckless misconduct, not with even gross negligence, so higher levels of negligence or more extreme levels of negligence. Only in cases of ordinary negligence can a service provider use a waiver as a defense. So keep that in mind as we're talking about the legal requirements here. One last thing I will mention here about waivers from a broader context is that it's kind of a tricky thing for courts to enforce because, on one hand, courts want to make sure that they are upholding tort law, right? So, someone's been wronged by an organization or an individual. It's the court's job to make sure those individuals are put back into the financial place they were prior to that wrong, right? We know that from our introduction to tort law. But on the other hand, it's up to the court to make sure they are enforcing contract law. So you can imagine that waivers create kind of a tough situation for a lot of courts because, on one hand, they do want to make sure they are putting plaintiffs back into the place they were prior to some kind of wrong that occurred to them, but they're also there to enforce a contract that exists. So it can be kind of a tricky situation for the court when they're determining whether or not to uphold a waiver as a defense. I'm sure you can think of lots of situations where you've been asked to sign a waiver in our field, either as a participant or as someone who is actually asking others to sign a waiver, maybe in an internship you've had or even a job you've had. So I won't go into those examples, but I'm sure you can list off a few in your mind as you're thinking about it now. We're going to look at some example waivers in class next week and really start to assess the validity of existing waivers. So if you haven't been able to really look at waivers and think about them, you'll get some hands-on experience to do that next week. Okay, so when we think about waivers and whether or not they're upheld, a couple things we have to talk about first. First is that the validity of a waiver really does vary based on the jurisdiction. So varies based on state, varies based on city, county. Every state has their own way of looking at waivers, and every judge has their own way of looking at waivers. So sometimes a waiver might be able to be used as a really strong defense depending on the state, depending on the judge, while other times a court might just throw out a waiver altogether. So as you're thinking about waivers and how they might impact you in this field, it's important to think about your surroundings, right? So whatever state you do end up working in, it's important to look at the precedents in terms of waivers in that particular state, right? Is this a state that tends to favor waivers as a defense, or is this a state that generally throws them out and doesn't use them as a defense? It's important to be aware of that context, right? Because you want to know how useful this tool might be in an actual negligence claim. Okay, so let's talk now about the different legal considerations for a valid waiver. So this is just the list directly coming from your textbook. I'm going to add a few things here as we go through and also point out some examples along the way, so hopefully this will bring it full circle for you. So first and foremost, in order for a waiver to be upheld in court, it has to be clearly written and easy to understand. What does that mean? Well, it means that an everyday lay person should be able to pick up that waiver, read it, and understand what it is they're agreeing to. So it's important that even though you might ask a lawyer for input in crafting a waiver for your organization, you want to be careful about not including too many legal terms that may not be understood by the everyday citizen, right? You know, not everyone is taking a class on waivers in college, so they're not going to be aware of some of the legal terminology that you are after taking this class. So we want to make sure that we're crafting a waiver that is easy for people to understand. That's going to make it easier to uphold in court, right? If a waiver is just full of legal terminology that the basic everyday person is not going to understand, the judge is probably going to throw that out, right? Because they would argue this person could never understand what it is they're actually agreeing to. Okay, so another consideration here for a valid waiver is that it has to be made obvious that it's a waiver. You might be thinking, well, that's ridiculous. Of course it should be obvious that it's a waiver. But you'd be surprised at how often we fail at this as K&R practitioners. So you've probably seen versions of waivers that look like this before. Giving you some examples. So this first one, this is the back of a ticket that someone would be given at a ski resort, right? So basically the waiver has been printed on the back of this ticket. Not real great from a validity standpoint, right? The concept here is that it has to be made obvious that it's a waiver. most people probably aren't reading whatever's written on the back of their ticket, right? So it's unclear that this is an actual legal contract. The same is true of sports event tickets. Oftentimes you'll get your printed ticket and it will have the waiver terminology written on the back of the ticket. And how often have you actually read that? You wouldn't be alone if your answer is not very often. So courts generally do not like it when K&R organizations do this kind of thing where they basically try to hide the waiver, right? Same is true here. Oftentimes you'll see waiver terminology just thrown in at the bottom of a brochure or a sign-up sheet. That is also not ideal from a court's perspective. Basically, what they want to see is a separate legal document with a clear statement that this is a waiver somewhere near the top of that document, right? That's best case scenario for being able to utilize that waiver later on as a defense. So certainly you could add verbiage like this as a reminder to what it is the person's agreeing to, but this should only be in addition to that separate legal document that folks are signing. Okay. Third one here, a waiver must be signed by one of majority age. Now your textbook goes into this a little bit, but I want to expand a bit. Basically, courts and judges in particular do not like it when parents or legal guardians sign away their child's right to sue someone. And therefore, often they do not uphold waivers that are signed on behalf of a minor. So we often ask it in our field, right? We'll have waivers prepared for youth sport activities or programming where we know that a minor can't sign a waiver and it be upheld as a legal document. So we ask the parents to sign that document. In most cases, particularly here in the state of Illinois, that contract will not be deemed legal or be able to be used as a defense in a negligence case. There have been a series of cases that have set a precedent both in the state of Illinois and in several other states here in the U.S. But again, basically courts do not like this idea that a parent can basically sign away the right of their child to sue. So in signing a waiver on behalf of your child in the state of Illinois, basically you agreed to give up your own right to sue that organization, but you cannot give up the right of your child to sue that organization. So those types of waivers that do ask for parent or guardian signature aren't going to be very useful as a potential defense in a negligence claim. And again, this is not just the state of Illinois. A lot of states feel this way as well. We'll talk in a little bit about maybe an alternative to a waiver when we deal with, programs or events that involve minors. Okay, fourth one here, a waiver must be specific as to what it covers. Basically what this means is a waiver should be very detailed in explaining who it covers, first of all. So who is covered legally in this waiver. That means you're very specific, right? You're not just saying the organization itself, but you're listing detailed groups of individuals who are covered by that waiver. So I've given you an example of a waiver here where they were pretty detailed in identifying who is covered, right? So not just the organization, but its officers, officials, agents, students, and or employees. So we've covered, a wide variety of people here in this waiver. So you want to be as detailed as possible in identifying who is covered. Again, in our field, we often rely on part-time employees or student workers. We'd want to be as detailed as possible as including those folks in our waiver, right? Because we don't want to just cover full-time employees or the owner of the organization. And a judge is going to look at that specific wording when it comes to viewing it as a potential defense. Did they actually list all of these people as being covered by the waiver? So really important to show not just what a waiver covers, but also who. So when we refer to what it covers, as you can imagine, that just means we want to be specific as to describing the potential risks involved for people signing the waiver, right? So we don't want to be general in this. We don't want to say, yes, there are potential risks in, participating in activities at this facility. No, we want to be very specific in, one, the types of activities that are involved, and the potential injuries that can occur because of them. So I've given you an example here of a fitness center waiver that's done a really good job of being specific in regards to the what. So they outline all the potential activities that could cause injury, and then they list the specific types of injuries that could occur, right? Anything from a joint or muscle tear to all the way to death, right? So they've been very specific in identifying potential injuries. Again, this is really important if you're going to use this document as a defense in court, right? You want to be able to point to your waiver and say, hey, we said that heart attack was a potential risk for this activity. You want to be able to point to that on the waiver. If your waiver is just general and says injuries can occur, that's not going to be as helpful in identifying, hey, we told this individual these were the risks specifically. So the more detailed you can get here, the better. Okay, fifth one here, a waiver must be signed voluntarily. Again, this one probably seems fairly straightforward, right? But it is illegal to force someone to sign a waiver. It is also illegal to have someone sign a waiver if they're under duress, meaning we can't put a gun to someone's head and say, hey, you have to sign this contract. It's also important that we have folks sign waivers before they're actually participating in an activity, right? So you don't want to end up in a situation where you're telling someone, hey, you can't actually complete this activity until you sign this waiver and you have to do it this second, right? So that would be considered putting someone in a place of duress. So really important that if you have a waiver as part of an activity or a program, that stuff's being taken care of long before any actual activity is taking place. So oftentimes important to have that taken care of at the front desk before you actually get to whatever activity is going to occur. Okay, sixth consideration here that's important for any waiver is that a waiver cannot be against public policy. What does that mean? You might be thinking. Basically what that means is a waiver cannot be illegal, right? Meaning that it can't cover illegal concepts in that waiver. So an example of this would be the minor situation, right? So waivers that say that they cover minors in cases of their parent or guardian signing them in a lot of states have been deemed to be against public policy, right? So this idea that you cannot sign away a minor's right to sue in a court of law is against public policy. So there are several other examples of that, and your book goes into some detail on that. Just know that in order for a waiver to be valid, it has to be a legal contract, right? It can't involve any kind of illegal content. Okay, a couple of other things to think about as we're constructing waivers or assessing waivers. We've gone over those core legal considerations, but there are a couple of other tidbits here I'd like to share that I think might be helpful. I already mentioned this before, but waivers really should be a standalone document if possible. Again, much easier to show proof that, hey, it was clearly made to this person that this is a waiver, right? It was a standalone document that they reviewed. It wasn't attached to some other long membership agreement or tagged onto the back of a ticket, right? If you can make it a standalone document, that's ideal. Also great if you can limit the length to 1 page of text. As you can imagine, that first legal consideration for a valid waiver, that it must be written clearly and easy to understand. Certainly, if you can keep things to 1 page, they're going to be easier to understand, right? In terms of keeping someone's attention span, probably far more likely to read through the content of a waiver if it's a single page versus 2-3 pages in length. In the digital age that we're living in, I think it's also important that you're making waivers available in multiple formats. So let's say that you have someone sign up for a run, like a 5K online. So it's okay to have a digital copy of that waiver, but if possible, it would also be nice to make a hard copy available on the day of the race, right? So that you're not just limiting a person to one format of that waiver. The more times you are showcasing that waiver, the better in terms of being able to use that as a defense later. Okay, a couple things in regards to language here. So, of course, we've already stated that it's important for the language to be clear and readable by any layperson. Someone who doesn't have a background in the law should be able to read and understand the content of that waiver. It's also important that there are some legal terms included, particularly the term negligence should be included in every waiver, right? We already said that waivers are put in place to protect facilities against cases of negligence. So if their primary purpose is to protect in cases of negligence, we better be including the term negligence in them somewhere, right? If not, it's not very useful to us in a negligence case. We talked a little bit about stating the specific parties that need to be protected and why that's important. And then this one I think is really important and one that gets lost on students a lot, and that's that waivers should really be written specifically for your organization. It's certainly tempting if you're charged with crafting a waiver for your organization to just go online, find other waivers that are already out there and sort of piece together your own waiver. But that's not going to be very helpful to your organization in an actual lawsuit, right? Because now you have some generic terminology. Things aren't specific to your organization in terms of who's covered, the types of risks involved at your facility. So while you could certainly look at other waivers or existing waivers to get some ideas for how to craft your own waiver, it's really important that you are creating a waiver that is specific to your organization. So basically, the more detailed you can get in identifying risks for your business, the better off you are. The more generic it is, the less likely it's going to be useful in court. Okay, the last piece here in regards to the waiver conversation is just showing you the core sections of a waiver. So basically, this is how a waiver should be put together in terms of the sections that you need in order for it to be considered valid. So I'm not going to go through detail here, but I have given you these different sections, and then I've also included an example here on the next slide so you can see exactly where these different sections are. So this is an example waiver from the U.S. Track and Field Association. So obviously I'll upload this set of lecture notes to our PowerPoint folder, so definitely take some time and look at these sections and see sort of where each section falls on a well-written example waiver here. This will be helpful to you, I think, when we get to our in-class activity next week where you actually get to assess some existing waivers. So make sure you take a few minutes to go over this section before class next week. Okay, one last thing I want to note here is that, I mentioned earlier that, it's basically illegal to have a minor sign a waiver, right? They cannot consent to waiving their rights to sue, right? That we know is illegal. You have to have the mental capacity in order to enter into a contractual agreement. Minors do not possess that mental capacity, nor do people who suffer from a disability. So we know that those individuals can't sign on their own behalf. We also know that a lot of states are not going to accept a waiver signed by a parent on behalf of a minor. So you might be thinking, well, what do we do if we work with kids, right? How are we protected? And one alternative to a waiver in these situations is what we call agreements to participate. So basically, it's similar to a waiver in that it's going to detail potential risks of the program or event, but it's not the same in terms of liability. So in an agreement to participate, you are basically shifting the liability to the parents, right? You're saying that because you're aware of all of these risks, you as the parent are now liable for any kind of injury that occurs to your minor. So instead of using a legal document like a waiver as a defense in a lawsuit involving a child, now you can say, hey, I'm going to use the assumption of risk defense because I have evidence here that the parent read through this agreement to participate, they acknowledged the potential risks, and they signed it. So that goes back to that concept of assumption of risk, right? So if you actually have written documentation that a parent agreed to have their child participate, that could be useful in terms of a defense. Again, important to consider the laws in the state that you're working, but oftentimes these agreements to participate are more helpful as a defense in a negligence claim than a waiver that, again, we basically said is useless if it's signed by the parent on behalf of the child. Okay, just to wrap up here in terms of our conversation on waivers, it's important to realize that even though a waiver might be thrown out in court as a defense, it can still be a useful legal tool for you as a practitioner. Certainly we want to work to write a solid waiver that's going to be upheld in court, but again, we don't always have control over whether or not that happens. You could run into a situation where a judge just doesn't like waivers and throws them out, and you can't do a whole lot about that. But even in cases where a waiver might not be able to be upheld, you can still use that waiver as part of your assumption of risk defense. So similar to what I said on the last slide, you can say, hey, this is an example of where the participant read about all these potential risks and they still participated in the activity, right? So you might not be able to use the waiver as a direct line of defense, but you can use it to bolster your assumption of risk defense, right? They knew these risks existed, they signed this paper, therefore there was an assumed level of risk. Also, having a waiver in place, regardless of whether or not it is upheld in court, generally reduces your likelihood of a lawsuit, right? You're taking this class, you're learning about various waivers and how useful they are in court, but the general public doesn't know all of the legal principles behind what makes a valid waiver, right? So just by signing a waiver, oftentimes members of the public believe, hey, I gave up my right to sue. They don't necessarily understand that there are caveats to that, or that maybe there are situations where a waiver could be thrown out. So oftentimes, someone signs a waiver, they believe they've given up their right to sue. So you'll find some states that are known for throwing out waivers in courts where recreation facilities still enforce waivers because they know that that's going to reduce the likelihood of someone actually filing a lawsuit.